stop everything you're doing right now, because what just happened in Washington, D.C. this week will determine whether you get to stay in America or face deportation. Three immigration bills just passed the House of Representatives in February 2026. And if you're an immigrant, a visa holder, someone waiting for a green card, or living undocumented in the United States, the decisions made in the next 6 months will literally change the course of your entire life. This isn't political commentary. This isn't speculation. This is breaking news that affects millions of people. And by the end of this video, you'll know exactly where you stand and what you need to do right now to protect yourself and your family. Welcome back to Entry Status USA, the channel that brings you the most accurate, up-to-date immigration news and analysis without the political spin. I'm here to break down complex immigration policy into information you can actually use to make decisions about your future. If this is your first time watching, go ahead and subscribe and turn on notifications, because immigration law is changing faster than ever in 2026. And staying informed isn't just helpful, it could be the difference between achieving your American dream and losing everything you've worked for. Today, we're doing a complete breakdown of three major immigration bills that just cleared the House of Representatives. I'm going to explain exactly what's in each bill, who will benefit, who will be hurt, what happens next as these bills move through the Senate, and most importantly, what specific actions you should take right now, today, to prepare for these changes, whether they become law or not. Let's get right into it. What we're witnessing right now is the most significant movement on immigration legislation since 2013, when the last major comprehensive reform effort collapsed in Congress. After years of gridlock, partisan fighting, and complete paralysis on immigration policy, three substantial bills just passed through the House of Representatives with bipartisan support. Political analysts are shocked. Immigration advocates are cautiously optimistic. Enforcement hawks are celebrating, and millions of immigrants across the country are asking the same question: what does this mean for me? The reality is that immigration affects Texas more than almost any other state in the nation. Texas has the longest border with Mexico, the second largest immigrant population in America, and communities that have been built by generations of immigrants who came here seeking better lives. Whether you live in Houston, Dallas, San Antonio, Austin, El Paso, or any of the hundreds of smaller communities across this massive state, these bills will impact your neighbors, your coworkers, your friends, and possibly you directly. Let me walk you through each bill in detail, and I'm not going to sugarcoat anything. You're going to hear the good, the bad, and the controversial, because you deserve to know the complete truth. The first bill that passed is called the Secure Border and Interior Enforcement Act of 2026. This is the enforcement-heavy legislation that focuses on border security, interior enforcement, and consequences for illegal immigration. The numbers alone are staggering. This bill authorizes $32 billion over the next 4 years, specifically dedicated to border security, infrastructure, technology, and personnel. To put that in perspective, that's more money than many small countries spend on their entire national budgets. Here's how that money breaks down. $12 billion will go toward physical barriers, meaning wall construction and reinforcement of existing barriers along the southern border in Texas, Arizona, New Mexico, and California. Another $8 billion is allocated for surveillance technology, including tower systems, drones, sensor networks, and advanced monitoring equipment. And $12 billion will fund the hiring and training of new enforcement personnel. Now, let's talk about personnel, because this is where things get very real for communities throughout Texas. The bill mandates the hiring of 15,000 new Border Patrol agents over the next 3 years. That's not a small number. That's essentially creating a small army of federal law enforcement officers whose sole job is border enforcement. On top of that, the bill requires hiring 8,000 new immigration and customs enforcement officers, commonly known as ICE agents. These ICE officers operate in the interior of the country, not just at the border, which means cities and towns throughout Texas and across America will see increased immigration enforcement activity. Training facilities for these new agents will be built in Texas, specifically in the El Paso region and the Rio Grande Valley. This represents a massive expansion of federal law enforcement presence that will be visible not just at the border, but throughout communities across the state as ICE operations expand their reach. One of the most controversial provisions in this first bill is the elimination of humanitarian parole for most asylum seekers arriving at the southern border. Right now, under current policy, many migrants who present themselves at official ports of entry and claim asylum are paroled into the United States while their asylum cases are being processed through the immigration court system. This bill ends that practice completely. Instead, asylum seekers will be held in newly constructed processing centers located on the Mexican side of the border, or in third countries that have signed agreements with the United States to house these facilities. The bill allocates $5 billion specifically for building and operating these offshore processing centers. Only after asylum seekers go through initial credible fear interviews and demonstrate that they have legitimate grounds for asylum will they be permitted to enter United States territory while their cases continue through the court system. Supporters of this provision argue that it will discourage fraudulent asylum claims and ensure that only people with genuine fear of persecution enter the country. Critics counter that this violates international refugee law and puts vulnerable people, including women and children fleeing violence, in dangerous situations while they wait in countries that may not be safe for them. The bill also creates what are called expedited docket systems for people already in removal proceedings. Immigration courts will be required to complete cases within 6 months for individuals who are detained and within 12 months for individuals who are not detained. Additional immigration judges will be hired to meet these compressed timelines. On the surface, faster processing might sound like a good thing. Nobody wants to wait years for their case to be resolved. But immigration advocates are sounding alarm bells because these accelerated timelines make it extremely difficult for applicants to gather evidence, locate and hire attorneys, and build strong cases for remaining in the United States. Perhaps the most far-reaching change in this enforcement bill is the dramatic expansion of crimes that make immigrants deportable. Under current law, aggravated felonies and crimes involving moral turpitude can trigger deportation proceedings. This new bill adds an entire category called crimes affecting public safety. This category includes DUI convictions, domestic violence misdemeanors, certain drug possession offenses, and even repeat traffic violations. What makes this particularly harsh is that even lawful permanent residents, people who have had green cards for years or even decades, can be placed in removal proceedings for these offenses. Let me give you a real example of how this could play out. Imagine someone named Juan who lives in Houston. He's been a green card holder for 12 years. He has a job, pays taxes, has built a life here. 3 years ago, he made a terrible mistake and got convicted of DUI. He paid his fine, completed his probation, and thought the chapter of his life was closed. Under this new bill, that single DUI conviction would make him deportable. ICE could place him in removal proceedings, and he would face deportation to a country he left when he was a teenager. His only defense would be to apply for something called cancellation of removal, which requires proving that his deportation would cause exceptional and extremely unusual hardship to his U.S. citizen children. The legal standard for this is incredibly high, and many people who apply for cancellation of removal are ultimately deported anyway. Now, let's shift gears and talk about the second bill, which takes a completely different approach. This one is called the Legal Immigration Reform and Backlog Reduction Act of 2026. While the first bill focused on enforcement and border security, this second bill aims to modernize the legal immigration system, reduce the crushing backlogs that have left hundreds of thousands of people waiting for years, and create new pathways for skilled workers and family members to come to the United States legally. The centerpiece of this bill is the elimination of per-country caps for employment-based green cards. This is huge. So let me explain why. Under current law, no more than 7% of employment-based green cards can go to nationals of any single country in any given year. This creates absolutely devastating backlogs for applicants from countries with high demand, particularly India and China. Highly skilled workers from these countries often wait 10, 15, or even 20 years for green cards, even though they're already working legally in the United States, paying taxes, and contributing to the American economy. This new bill eliminates these per-country caps entirely, allowing green cards to be issued based purely on priority date, regardless of what country you were born in. For Indian and Chinese nationals stuck in the EB2 and EB3 employment categories, this change would dramatically reduce wait times. People who thought they'd be waiting another decade might get their green cards within just a few years. The bill also increases the overall annual cap on employment-based green cards from 140,000 to 250,000. And here's the really interesting part. Additional automatic increases are triggered if demand exceeds supply in any given year. This addresses the fundamental economic reality that the American economy needs skilled workers, particularly in technology, healthcare, engineering, and other specialized fields. To be eligible for this program, you must meet several strict conditions. First, you must have continuously resided in the United States since January 1st, 2020. That's the hard cutoff date. If you entered the country after January 1st, 2020, you do not qualify for this program. Period. Second, you must have no felony convictions and no more than 2 misdemeanor convictions. Third, you must demonstrate continuous employment, enrollment in education programs, or status as a primary caregiver for a dependent family member. Fourth, you must pass comprehensive background checks and biometric screening. And fifth, you must demonstrate basic English language ability and knowledge of United States civics and government. If you meet all of those requirements, you can apply for what the bill calls conditional resident status. This is not a green card. This is not citizenship. This is a temporary legal status that's valid for 8 years. During those 8 years, you must maintain continuous employment or enrollment in education, pay all of your taxes, refrain from committing any crimes, and check in annually with immigration authorities to verify your continued compliance. After completing 8 full years in conditional resident status, if you've met all requirements without any interruptions or violations, you can then apply to adjust your status to lawful permanent resident, which means getting an actual green card. After you obtain your green card, you must wait an additional 5 years before you can apply for citizenship through the standard naturalization process. Do the math. The total timeline from undocumented status to citizenship under this program is at least 13 years. The bill does include special provisions for Dreamers, which refers to individuals who were brought to the United States as children. If you entered the country before your 16th birthday, have lived in the United States for at least 10 years, and have graduated from a U.S. high school or obtained a GED, you qualify for expedited processing. Dreamers can obtain conditional resident status immediately and adjust to permanent residency after just 5 years instead of 8, cutting the total pathway to citizenship down to 10 years instead of 13. The application process requires extensive documentation proving continuous residence in the United States since January 2020. Acceptable documents include rental agreements, mortgage statements, utility bills in your name, bank statements, employment records with pay stubs or tax documents, school enrollment records, medical records with dates of service, and sworn affidavits from U.S. citizens or permanent residents who can verify your presence in the country during that time period. Here's the problem. Many undocumented immigrants live in circumstances where obtaining formal documentation is extremely difficult. They pay rent in cash without formal lease agreements. They work off the books without official pay stubs. They share housing with others without their names appearing on utility bills or lease documents. The burden of proof required by this bill will be extraordinarily challenging for many people who otherwise meet the eligibility requirements. The fee structure is also substantial and will be a barrier for many families. The initial application for conditional resident status costs $2,000 per adult and $1,000 per child. After 8 years, the application to adjust to permanent residency costs another $2,500 per person. Combined with eventual naturalization fees of $760, a family of 4 could end up paying over $15,000 in government fees alone over the 13-year process. That doesn't include attorney fees, document translation costs, or other associated expenses. During the entire period of conditional resident status, applicants are explicitly prohibited from receiving federal public benefits. This includes Medicaid, except for emergency services, SNAP food assistance, federal housing programs, and subsidies under the Affordable Care Act. You can work legally and pay taxes into the system, but you cannot access the social safety net even in times of genuine hardship or emergency. Only after adjusting to lawful permanent residence do you become eligible for these programs, and even then you're subject to the usual waiting periods that apply to all green card holders. Texas has an estimated 1.7 million undocumented immigrants living within its borders. If this bill becomes law, immigration experts estimate that somewhere between 800,000 and 1 million Texas residents could potentially be eligible based on the January 2020 residency requirement. Major metropolitan areas like Houston, Dallas, Fort Worth, Austin, and San Antonio have large undocumented populations who have established deep roots in their communities, raised families, built businesses, and contributed to local economies over many years. This bill offers them a genuine chance at legal status, but the path forward is long, expensive, and filled with requirements that will inevitably exclude many people who desperately need relief. Let me give you another real example. Imagine a woman named Rosa who lives in San Antonio. She entered the United States without authorization in 2018 with her 2 children. She's been working as a housekeeper, pays rent for her apartment, and her children attend public school. On paper, Rosa would qualify for this program because she's been in the country continuously since before January 2020. She has no criminal record and has maintained steady employment, but she faces enormous practical challenges. She must prove she's been in Texas since 2020, which means gathering years' worth of documents. She's moved apartments twice, and her earlier landlords may not remember her or be willing to provide verification letters. She's worked for different families, cleaning houses, and some of them paid her in cash without any documentation. Building a strong enough application to satisfy USCIS requirements will require months of effort and quite possibly hiring an immigration attorney, which she can barely afford given her income. Now, here's what's absolutely critical for everyone watching to understand. These 3 bills have only passed the House of Representatives. They now move to the Senate, where the political landscape is very different. The Senate is narrowly divided, and immigration remains one of the most divisive and contentious issues in American politics. Several different scenarios are possible from here. The bills could pass the Senate largely unchanged if enough senators from both parties decide to support them. The bills could be significantly amended through negotiation, with provisions added, removed, or modified to gain more votes. The bills could be combined with other legislation in a larger package deal. Or the bills could fail entirely if they cannot gain the 60 votes needed to overcome a filibuster. Even if the bills pass the Senate, they must be signed by the president to become law. The president has publicly expressed support for comprehensive immigration reform and has indicated that these bills generally align with administration priorities. However, specific provisions, particularly some of the harsher enforcement measures, may face opposition from within the administration itself. Negotiations between Congress and the White House could result in significant changes before final enactment, assuming the bills do eventually become law. Implementation will not happen overnight. Federal agencies must write detailed regulations explaining exactly how the laws will be applied. USCIS must create application forms, build computer systems, train staff members, and establish procedures for processing applications. The Conditional Resident Status Program would likely take 8 to 12 months after enactment before applications could even be accepted. Border enforcement provisions would be phased in gradually as funding is appropriated, personnel are hired and trained, and facilities are constructed. Changes to visa categories and processing systems would require major systems updates and extensive staff training. So, what should you do right now to prepare for these potential changes? Let me give you specific, actionable steps you can take today. First, if you're undocumented and potentially eligible for the Earned Pathway program, start gathering documentation immediately. Don't wait for the bill to become law. Don't wait to see what happens in the Senate. Start now. Collect every single piece of evidence that shows your presence in the United States since January 2020. Request letters from landlords, employers, schools, doctors, churches, and anyone else who can verify that you've been here. Make copies of utility bills, rent receipts, money transfer records, anything and everything with your name and a date on it. Organize these documents chronologically and keep them in a secure place. If the bill becomes law and the application window opens, you want to be among the very first people to apply. Second, if you've been paying taxes using an individual taxpayer identification number, known as an ITIN, make absolutely certain you file your 2024 and 2025 tax returns on time. Tax returns are one of the strongest pieces of evidence you can provide for proving presence in the country and demonstrating good moral character. If you haven't been filing taxes, start now. Even if you've earned income off the books, consult with an immigration knowledgeable tax professional about filing returns that document your work history without exposing you to other risks. Third, avoid any criminal activity, no matter how minor it might seem. Even a misdemeanor conviction could jeopardize your eligibility for the Earned Pathway Program or any other future relief. If you have old criminal cases that were dismissed or resolved favorably, obtain certified court records showing the final disposition. You'll need these documents for any future immigration application. Fourth, if you're in the United States on a temporary visa, be absolutely meticulous about maintaining your status. Do not overstay your authorized period of stay. Do not work without authorization. Keep your address updated with USCIS. The bills expand penalties for status violations, and even minor violations could affect your future applications or make you ineligible for benefits. Fifth, if you're waiting in the employment-based green card backlog, particularly if you're from India or China, the Legal Immigration Reform Act could dramatically reduce your wait time if it becomes law. However, don't make irreversible life decisions based on pending legislation that hasn't been enacted yet. Monitor the situation closely, stay informed, but maintain your current status and continue with your existing applications. Sixth, if you're a U.S. citizen who's been planning to sponsor a sibling for immigration, understand that this category may be eliminated. If you haven't yet filed an I-130 petition for your brother or sister, do so immediately. The bill includes a grandfather clause that protects petitions filed before the law takes effect. Filing now preserves your sibling's place in line even if the law changes. Seventh, be extremely vigilant about immigration fraud. Whenever major immigration legislation is pending, scammers multiply like crazy. They promise help with applications that don't yet exist. They charge fees for services they cannot legally provide. They take money from vulnerable people who are desperate for legal status. Only work with licensed attorneys or DOJ accredited representatives. Never pay cash without getting receipts. Never sign blank forms and never let anyone keep your original documents. Eighth, if you're an employer who sponsors foreign workers, start planning now for potential changes. If the employment-based reforms pass, you'll have significantly more options for hiring and retaining international talent. Work with your immigration attorney to identify current employees who are stuck in backlogs and could benefit from these changes, and prepare to act quickly when new rules take effect. The passage of these three immigration bills through the House of Representatives represents a truly historic moment. For the first time in over a decade, comprehensive immigration legislation addressing enforcement, legal immigration pathways, and undocumented populations has moved forward with genuine bipartisan support. Whether these bills ultimately become law remains uncertain, but the fact that they passed the House demonstrates that political will for immigration reform exists even in our deeply divided government. For immigrants throughout Texas and across the United States, these bills represent hope, anxiety, opportunity, and risk, all mixed together. The enforcement provisions create new dangers for undocumented immigrants and expand the grounds for deportation that could affect even legal permanent residents. The legal immigration reforms offer relief to hundreds of thousands of people stuck in crushing backlogs and create new opportunities for skilled workers and entrepreneurs. The earned legalization pathway provides a chance for millions to emerge from the shadows and build legal lives, though the requirements are steep and the road ahead is long. Here at Entry Status USA, we'll be monitoring this legislation every single step of the way. We'll track the Senate debate as it unfolds. We'll analyze any amendments that get proposed. We'll report on final passage or failure, and most importantly, we'll provide you with detailed, practical guidance on how to navigate these changes if and when they become law. Immigration law is complicated. The political process is unpredictable. Reliable information is hard to find. That's exactly why this channel exists, to give you the facts, the analysis, and the practical advice you need to make informed decisions about your future. If this video helped you understand the 3 immigration bills that just passed the House and what they could mean for your future, please hit that like button and share this video with family, friends, and anyone in your community who needs this information. Subscribe to Entry Status USA if you haven't already, and turn on notifications so you receive instant alerts as this situation develops in the Senate and beyond. Drop a comment below and tell us how these bills would affect you personally. Are you potentially eligible for the Earned Pathway program? Are you waiting in an employment backlog? Are you worried about the enforcement provisions? What questions do you have? Your engagement helps us create content that addresses your real concerns and provides the information you actually need. Your future matters, your family matters, your American dream matters. Stay informed, stay prepared, and never stop fighting for your place in this country. This is Entry Status USA, and we're here with you every step of the way. We'll see you in the next video.